If you or your loved one are facing a felony charge in California and already have a prior strike on your record, you're standing on the edge of a financial and personal cliff. Right now, the state is trying to come after you and use your past against you to lock you away for decades, or potentially even the rest of your life. But a prior strike does not mean your life is over. By the end of this video, you will know the exact legal mechanics that can be used to strip away those prior strikes and how to avoid a mandatory life sentence. I'm also going to show you the proactive 3-step blueprint that you can use to transform your defense from a losing battle into a narrative of true recovery and change that judges cannot ignore. If you stay passive, rely on standard reactive defense strategies, or just hope for the best, you risk letting the system permanently tear you and your family apart. I know some of you might wonder, why should we listen to you? Who are you? My name is William Pernik. I'm a certified specialist in criminal law by the State Bar of California and a founder of the Pernik Law Firm. For the past 20 years, I have stood in countless California courtrooms as a criminal defense attorney, fighting the exact battles we're going to be talking about today. I don't just read these laws out of a textbook, I navigate them daily to save real people from life sentences. And what you're about to hear in this video is the exact playbook that me and my colleagues use to protect our clients' freedoms in court. Now, let's strip away the legal jargon and understand exactly what a strike is. California's 3 strikes law is what is known as a habitual offender law. The core philosophy behind it is simple. The state believes that if a person commits a new crime after they've already been convicted of a serious or violent offense in the past, their punishment should automatically be jacked up. And so, in the standard criminal case, the judge is going to evaluate the current crime and apply an appropriate normal sentence. But that changes once you have a prior strike on your record. In those cases, the law triggers a mandatory penalty increase before your case gets resolved at sentencing. The system stops looking at just the crime you're accused of today and automatically doubles your prison exposure, denies you probation, or even locks you up for life based entirely on your past history. A strike is not an independent charge. It's a label that gets attached to specific past felony convictions that the law classifies as either violent or serious. And they're defined by 2 distinct statutes in the California Penal Code. The California legislature, for example, has created a list under Penal Code section 667.5, subdivision C. And that list contains 23 distinct categories of crimes that it considers violent felonies. So, if your offense happens to be on that list, you're now looking at a violent felony conviction or a violent strike, and you will have to serve 85% of your sentence in prison. The offenses on the list will include some of the most serious crimes you can think of: murder, rape, child molesting, mayhem, carjacking, kidnapping, any felony where great bodily injury was personally inflicted on a person. There's another list in section 1192.7, subdivision C. Those are serious felonies. There are a lot more serious crimes than violent crimes, and this list contains more than 40 specific categories. Now, every violent felony is automatically included as a serious felony, but not every serious felony is violent. Examples of serious crimes include first-degree residential burglary, if nobody was home, assault with a deadly weapon, criminal threats. Once you have these serious or violent convictions on your record, that penalty increase I was talking about earlier gets locked in. You're no longer fighting a case like everyone else. You're now fighting a system that's designed, that's programmed to exceptionally heavily punish you based entirely on your past history. Now, to fight this system effectively today, we have to talk about how this landscape has evolved. California's 3 strikes law was originally passed in 1994, and it was brutal. Under the old rules, if you had 2 prior strikes, any 3rd felony conviction, even if it was not a strike itself, could trigger a mandatory prison sentence of 25 years to life. In 2012, California voters finally passed Proposition 36 to change this. And so under current law, if your 3rd felony is non-violent and non-serious, the court can no longer give you 25 years to life. However, if your new charge is classified as a serious or violent felony, or if you fall into one of very few exemptions, you could still be facing a life sentence. And because the legal definitions are so rigid, the system frequently tries to hand out life sentences for offenses that we consider, normal people consider, to be pretty minor. To show you how heartless this law can be, I'm going to share with you some real example of clients that I have defended in my career. Years ago, when I was a public defender, I represented a man who was deeply struggling with severe heroin addiction. My client not just an open garage door, walked a few feet inside and picked up a pair of cheap $3 pruning shears to sell for quick drug money. But because an attached garage is legally considered part of a home, he was charged with a residential burglary, which is a serious strike. And because of his past residential burglary convictions, the state now used those $3 shears to try to lock him up for life. I've also defended a homeless woman who was starving and stole a single box of sushi from a supermarket. Under normal circumstances, shoplifting is a misdemeanor, but back in those days, a petty theft with a prior was considered a felony. And so a judge gave my client 32 months in prison, doubling her sentence, and told me it was a gift because she stole a luxury food item. Finally, I represented a woman who was a survivor of horrific sexual assault. To cope with the unresolved trauma, she developed severe drug addiction. And so one day, while she was shoplifting in Walmart, she was violently grabbed by loss prevention. This instantly triggered her trauma, causing her to panic and try to flee and fight off the security guards. The prosecution didn't care about her psychological triggers, so they charged her with Estes robbery for using force to escape with stored property, exposing my client to a devastating, lengthy prison term. Although I was able to help clients, like the examples I gave you, as you can see, the law contains massive traps. Specifically, even after Proposition 36, there are 3 major exceptions you must know, which include being a felon in possession of a firearm, being engaged in sales of drugs, and being charged with a crime that would require sex offender registration. If any of these 3 exceptions apply, even though you're charged with a non-strike felony, you would be subject to the old pre-Prop 36 law and could now be facing a life sentence. Now, one of the things you may hear a lot about is something called a Romero Motion. The Romero Motion refers to a case where in 1996, California Supreme Court has ruled that trial judges actually possess discretion under Penal Code Section 1385 to dismiss or strike a prior strike conviction in the furtherance of justice. So when a defense attorney like me files a Romero motion, the judge has to consider it under specific legal circumstances. They cannot grant it because they feel sorry for you or deny it because they don't like you. Instead, they have to apply a legal standard that comes from a case of People versus Williams. They have to take a look at your case, at your past history, and decide whether or not you fall within or outside the 3 strikes law and its spirit. Some of the factors that the court will look at to make this determination will include the length of time between your old strike and your new offense. The older is your strike, the more likely it's going to weigh in your favor. The more recent, the more it's going to weigh against you. The court is going to take a look at your past offense and compare it to the current offense. And they're going to look specifically at its nature and severity. They're going to look at your age, your medical health, your personal background, and they're going to consider your prospects for rehabilitation and whether removing the strike will pose an unreasonable risk to public safety. So thinking back to my client who stole the $3 pruning shears, or the client who was triggered at Walmart, a skilled Romero motion would argue that a drug addict or a traumatized sexual assault victim is exactly the type of person who falls outside of the spirit of the law that's meant to punish hardened career criminals. If a judge grants the Romero motion, the strike would be set aside for sentencing, opening the door for a reduced term of formal probation instead of prison. Now, a common misconception is that a Romero motion, once granted, will completely erase a prior strike from your rep sheet for future purposes. That's not true. It does not. It only bypasses the strike for your current sentencing. If you catch a new case in the future, your old strike can be charged against you again. Just because the court struck your strike in the past in an old case does not mean they're going to do it again, over and over. That's exactly why immediate, permanent, lifestyle transformation is non-negotiable for you. Now, most traditional law firms handle a Romero motion purely through paperwork. They research your past record, they gather character letters, they compile your medical history, and they file a standard brief summarizing the law. They're entirely reactive, and they wait for the sentencing date, look at the judge, and beg for mercy. At the Pernik law firm, we do it differently. We recognize that begging does not work when the judge is looking at a serious criminal history. You cannot just tell a judge you want to change. You must prove you are already changing. That's exactly why we developed our unique three-step method, which shifts your defense from a defensive posture to an offensive, proactive courtroom strategy. We don't look at your case as a simple violation of the penal code. Instead, we look at your case and we ask the question, why? Why did this behavior occur? For our client at Walmart, the root cause obviously wasn't a desire to hurt security guards. It was a severe, untreated trauma from a past sexual assault mixed with drug addiction. For the man who stole pruning shears from the garage, it was a severe chemical dependency. So we have a job in front of us. We have to dig deep and we have to uncover these often hidden driving forces. Once we isolate the root cause, we immediately work to build a comprehensive, individualized treatment narrative. We do not wait for a court order. Instead, we place our clients into intensive, outpatient programs, residential treatment programs, specialized types of therapy, or trauma-informed counseling. And finally, this is where the magic happens. By the time your Romero motion is actually heard by the judge, we don't show up with a list of promises. We present a stack of clean drug test results, progress reports from licensed clinicians, and proof of active compliance. We show the judge that you, our client, are a completely different person today than you were the day you got arrested. We demonstrate recovery in real time, proving to the court that granting this motion will serve public safety by permanently fixing the underlying problem. Now you gotta understand, judges face immense pressure, often political pressure, when they deal with three strikes cases. If they show mercy too often and the defendant reoffends, it makes the evening news. So by providing the judge with objective, verified, reliable clinical data from your proactive treatment, you give them the legal and psychological cover they need to confidently rule in your favor. I also want to be clear, a Romero motion is a powerful legal tool, but it is not your only option. Depending on specific facts of your case, we can often bypass the traditional criminal pipeline entirely through California's statutory diversion programs. These programs allow you to pause or suspend criminal proceedings entirely, complete a structured treatment regimen, and ultimately get your charges dismissed without ever triggering the harsh three-strike sentencing. One example of this is military diversion under Penal Code Section 1001.80. If you are a current or former member of the United States military who suffers from PTSD, traumatic brain injury, substance abuse, or psychological trauma, or another form of mental illness as a result of your military service, you may qualify for military diversion. The court can suspend your case and place you in treatment for up to 2 years. And once your treatment is completed, the case will be dismissed, and your arrest, it will be legally sealed, like it never happened. Under Penal Code Section 1001.36, known as mental health diversion, if you have a diagnosed mental health disorder, such as schizophrenia, bipolar, depression, anxiety, one of many conditions listed in DSM-5, and you can show that that condition played a significant role in the commission of the alleged crime, you may similarly qualify for diversion. Your defense team will have to present a structured treatment plan and will likely have to hire a qualified mental health expert. And if the court is satisfied after a hearing that your condition can be safely and effectively treated within the community, they will divert your case. Succeeding in this program can completely avoid a future prison sentence, dismiss the charges, and protect your future. What's really amazing is that under this program, even some very serious offenses can qualify for diversion, provided they're not explicitly excluded by statute, such as murder or rape. And so if you suffer from these conditions, but your attorney is not actively evaluating your history from day one, they might be leaving one of your most potent defense assets completely on the table. If you or someone you love is currently facing a strike allegation, you cannot afford to sit back and just watch the prosecution dictate the narrative. You gotta take control of your case immediately by executing these specific steps. Number 1, you should immediately obtain the complete record of conviction for your past strikes to check for any structural, procedural, or legal errors. Next, you need to undergo professional clinical evaluation. That means your attorney should secure an independent assessment from a licensed forensic psychologist or addiction specialist in order to isolate the root causes of your past behaviors. Next, you need to enroll in proactive treatment. Don't wait for court to tell you to get help. If you know that you need help, enroll in rehabilitation, counseling, or therapy programs. immediately. Have your legal team thoroughly analyze your background for past military service or qualifying mental health or substance abuse disorders. And when you do draft a Romero motion, ensure that your attorney drafts a motion that tells your entire life story, directly addressing the Williams factors rather than just reciting generic legal principles. I hope you found this video helpful. And if you happen to be in my area and you want a team that refuses to simply process you through a broken system and instead focuses on total, complete human transformation and proactive advocacy, please give us a call. Let's start analyzing your life. Let's look at your entire story, and let's start repairing and building your future together. My name is William Pernik. Let's get to work.